Okay guys, so today we'll start with Article 14 of the Constitution of India. So Article 14 of the Constitution of India reads as equality before law. The state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. So now, what does Article 14 or right to equality mean? I mean, we have heard this term or phrase time and again since our childhood, but do you actually understand what it means? So, Article 14 guarantees to every person the right to equality before the law and equal protection of laws. That means there are two phrases inside this particular one article. So, the first phrase or expression, equality before law, is a declaration of the equality of all persons within the territory of India, thereby implying the absence of any special privilege in favor of any individual. So basically, it is very clear that everyone will be treated equally. So there won't be any kind of privilege that will be given to any particular person. In that case, what does the second expression say? The second expression, the equal protection of laws, is a corollary of the first and directs that equal protection shall be secured to all persons within the territorial jurisdiction of the country in the enjoyment of their rights and privileges without favoritism or discrimination. The underlying purpose of two expressions is to give widest amplitude to Article 14 as much as possible. So that means the second expression is a corollary of the first and merely widens the whole expression or gives a better and wider interpretation to the whole interpretation. So now, if everyone is equal in front of the eyes of the law, then why do we give reservation? Is it not antithesis of Article 14 itself? Is it not contrary to Article 14? So, in order to understand that, we have to first understand the underlying principle of Article 14. Now, as no two human beings are ever equal in all respects, a similar treatment to them in every respect would result in an unequal treatment. So, what does that mean? That means if people are not equal, then you cannot treat them equally. That will be the greatest injustice. Therefore, the underlying principle of equality is not the uniformity of treatment to all in all respects. Rather, you give same treatment to those people who are similar and people who are not similar, you treat them differently. In other words, equals must be treated equally, whilst unequals must be treated differently. So if you can see this picture, it is a very famous picture which is viral on Facebook and other social media sites. You will see that the first picture says equality. That means you are blindly treating everyone equally, irrespective of their own status. But in the second case, it is talking about equity, where you treat them according to their status or their situation. So similarly in country, we cannot treat everyone equally blindly because everyone has different socio-economic status. So we have to treat them differently in order to give justice. Similarly, the Supreme Court has time and again reiterated that Article 14 does not rule out reasonable classification. In Kedarnath Bajoria versus State of West Bengal, the Supreme Court observed that equal protection of laws guaranteed by Article 14 of the Constitution does not mean that all the laws must be general in character and universal in application, and that state is no longer to have the power of distinguishing and classifying persons or things for the purpose of legislation. Now, what do you mean by classification? Classification means the whole act of treating few people differently than others. So when can the state treat few people differently than others? Or what is the test for a valid classification? In order to pass the test of permissible classification, two conditions must be fulfilled. First, the classification must be founded on first intelligible differentia. So what do you mean by intelligible differentia? Intelligible differentia is a classification or grouping a few people which distinguishes persons or things that are grouped together from others left out of the group. That means, let's say there are 5 students in a particular class. I want to treat 2 out of those 5 students differently from others. So what is the reason behind it? There must be a reason why I am treating those 2 people differently than 3 people. That is reasonable classification, or in other words, reasonable classification based on intelligible differential. Second, The differentia must have a reasonable nexus in connection to the object to be achieved. So, when I want to treat those two students differently from the three students, there must be a particular reason why I want to treat them. Maybe they don't come from similar socioeconomic background. They don't have money to buy like a cell phone for online classes. So I want to give them some kind of money or some kind of advantage or some kind of benefit where they can also access online classes. Since the other three people can afford online classes, I am treating not them differently. And since these two people cannot afford online classes, I am treating them differently. So first, there must be a reason why I am treating them differently. That is intelligible differentia. Second, that particular intelligible differentia must have some kind of reasonable nexus with the object I am trying to achieve. My object is to make the whole class accessible to online classes, right? So now coming to a few important cases relating to Article 14. In the case of E.P. Royappa versus State of Tamil Nadu. Hello students, today we are going to start with section 304B of the Indian Penal Code, which deals with dowry death. Now, 304B reads as, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. Explanation: for the purpose of this subsection, dowry shall have the same meaning as in section 2 of the Dowry Prohibition Act of 1961. 2. Whoever commits dowry shall be punished with imprisonment for a term which shall not be less than 7 years but which may extend to imprisonment for life. So now, this particular section was inserted by the Dowry Prohibition Amendment Act 1986 with a view to combat the increasing menace of dowry deaths. This section will apply whenever death is preceded by cruelty or harassment by husband or in-laws for dowry and death occurs in unnatural circumstances. The intention of section is to fasten the guilt on the husband or in-laws. Now, the ingredients of this section are that the death of a woman was caused by any burns or bodily injury or in some circumstances which were not normal, that means it was not a natural death. Second, such death occurs within 7 years from death of her marriage. Third, that the victim was subjected to cruelty or harassment by her husband or any relative of her husband. Fourth, such cruelty or harassment was for or in connection with demand of dowry. Fifth, it is established that such cruelty or harassment was made soon before her death. So these are the five ingredients. First, there must be any burns or bodily injury or in other circumstances where her death cannot be considered normal or natural. Second, the death must have occurred within 7 years of marriage. Third, there must be cruelty or harassment inflicted upon the victim by the husband or any relative of the husband. Moreover, such cruelty or harassment must be in connection to demand of dowry. So, if a cruelty or harassment is inflicted but it is not in connection with demand of dowry, then it cannot come under the ambit of dowry death. Similarly, such cruelty or harassment must have been made soon before her death so that there is a proximate connection between the dowry death and the demand for dowry. So that in total it can come under the ambit of dowry death as it will satisfy all the ingredients. Now coming to dowry, what does dowry exactly mean? So the section itself says that it shall carry the same meaning as that of Dowry Prohibition Act. So dowry must consist of money, property or valuable security of any kind. Such property or security can be given or agreed to be given. That means actual giving of such property or security is not necessary. The fact that such a fact was being discussed or being said or a prospective change of hand on of property can also amount to asking for dowry. So next is, this is an exception to the general rule of penal laws. How? Let us read. Presumption under section 304B of the Indian Penal Code and 113B of the Evidence Act. If all the above mentioned ingredients that we just discussed, all the ingredients are fulfilled or satisfied, then section 304B mandates that the husband or such other relatives of the husband shall be deemed to be guilty of causing dowry death. So they are deemed to be guilty. Both section 304B and 113B of the Evidence Act have used the expression shall be presumed or shall be deemed. So what does that mean? So in order to understand what shall be presumed or shall be deemed mean, we must go back to our video under Indian Evidence Act. So section 4 clearly defines what shall be presumed means, right? So now coming to section 304B and 113B of the Evidence Act, they are an exception to the cardinal principles of criminal jurisprudence. That is, suspect in the Indian law is entitled to protection and presumption of innocence in his favor. However, in this particular case, if the above mentioned ingredients are satisfied, then there cannot be any presumption of innocence in his favor. Rather, they are deemed to be guilty. So the concept of deeming fiction is hardly applicable to criminal jurisprudence other than this particular section. But in contradiction to these aspects of criminal law, the legislature applied the concept of deeming fiction to the above mentioned provisions. Such deeming fiction resulting in presumption is however rebuttable. So obviously it is rebuttable, then the burden of proof lies on the defendant. So why do we have a deeming provision and why do we have a deeming fiction over here which is applicable on criminal and penal laws contrary to the general penal laws? Because of the menace of dowry. It is so prevalent that it was very necessary to incorporate such stringent laws in order to do away with such social evils. Hello students, today we'll start with section 16 of the Indian Contract Act, that is undue influence. So section 16 reads as, a contract is said to be influenced by undue influence where the relation subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. 2. In particular, and without prejudice to the generality of the foregoing principle, a person is deemed to be in a position to dominate the will of other, A, where he holds a real or apparent authority over the other, or where he stands in a fiduciary relation to the other, B, where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental or bodily distress. 3. Where a person who is in a position to dominate the will of another enters into a contract with him and transaction appears on the face of it or on the evidence adduced to be unconscionable, and burden of proving that such contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other person. Nothing in this subsection shall affect the provisions of section 111 of the Indian Evidence Act. Now, what do you mean by undue influence? Can one person influence the other person? Yes, easily. So does it mean that any person who influences the other person, that means the whole contract or the whole arrangement or the agreement is vitiated by undue influence? For example, let's say if I go to a shop, I want to buy a Samsung cell phone, but the salesperson influences me and sells me a Nokia cell phone. Would that be undue influence? Now, every influence is not undue. So, when does an influence become undue? Let us understand. Sometimes the parties to an agreement are so related to each other that one of them is able to dominate the will of the other. The person who occupies the superior position may prevail upon the other party and obtain his consent to the agreement to which he would not have consented but for the influence. The superior position is a sine qua non for the undue influence. So what does this mean? What does superior position being a sine qua non for the undue influence mean? That means it is very important that when there are two parties, one party is in such a superior position that it can easily dominate or influence the other person. Similarly, the other person is in such a position that he can easily be dominated by the other person. Why? Because the relationship is such. So, when can we presume that there would be a relationship where undue influence can happen? Presumption of undue influence is raised and it is presumed that defendant must have used his position to obtain an unfair advantage if the following ingredients are satisfied. First, there must be a subsisting relationship. That means the relationship is pre-existing. That means if I go to a shop, I don't know that person. So that person can never have a superior position over me. That means he can never have an undue advantage over me. So, second is defendant was in a position to dominate the will. So, obviously, if the other person does not have a superior position, he cannot dominate the other person's will. There are certain relationships which especially reek of domination. So, what are those relationships? The Indian Contract Act specifically under 16 clause 2 lays down that a person is deemed to be in a position to dominate the will of the another if number 1 where he holds a real or apparent authority over the other or where he stands in fiduciary relation to the other. So we'll come to all these terms one by one very soon. Number 2 where he makes a contract with a person whose mental capacity is temporarily affected by region of age, illness, mental or bodily distress. So these are the two special relations or special conditions where one can easily presume that definitely there is a undue influence involved. If there is an agreement, then definitely there is a chance of undue influence. So the first is real or apparent authority. A person who is in authority is definitely in a position, a superior position to dominate the will of the other person. The authority may be real or apparent. So an employer employee is a real authority. So the employer is a real authority over the employee. So what do you mean by apparent authority? Apparent authority is not exactly an authority over that person, but since he has a certain position or certain office, so by virtue of that particular position, he exercises his influence over other people. For example, if a police officer comes and says something to a layman, then that person can easily get influenced by the virtue of the authority of the police officer. So that can be an apparent authority. Next is fiduciary relation. So any relationship based on trust and confidence is a fiduciary relation. For example, an advocate and his client. Obviously, the client completely trusts his advocate. Spiritual advisor and his devotee. Doctor and patient. Parent, guardian and their children. So whenever there is blind trust and confidence involved, that relationship becomes fiduciary. So obviously in such a relationship where there is blind trust and confidence, they completely depend on the other person and therefore the other person is in a superior position and can easily dominate the will of this other person. The last part, mental distress. So a person who is suffering from mental or physical distress is easily vulnerable to all kind of influence. That means any other person can come and take undue advantage of this person and his illnesses. Therefore, these people are very susceptible to undue influence. Now coming to applicability and presumption of undue influence, there are few other factors or few other cases where it is directly presumed that undue influence is rampant. Such factors are where there are unconscionable bargains or inequality of bargaining power or economic duress or where a Pardanashin woman is involved. Now coming to unconscionable bargaining, we will be starting with section 6 of the Indian Evidence Act. So section 6 reads as relevancy of facts forming part of same transaction. Facts which, though not an issue, are so connected with the fact in issue as to form part of the same transaction are relevant whether they occurred at the same time and place or at different times and places. So now, in the case of Babulal versus WIT Limited, it was observed by Supreme Court that Rule 6 or Section 6 is also known as the rule of res geste. According to this doctrine, certain facts which are not in issue are so connected to the facts in issue that they cannot be severed. So they form part of the same transaction and therefore become relevant just like fact in issue. So usually hearsay evidence is not admissible. But this particular section is an exception to the general rule whereupon hearsay evidence becomes admissible. How? So, for bringing such hearsay evidence within the provisions of this section, it must be proved or established that it must be contemporaneous with the acts and there should not be an interval which would allow fabrication. Or, in simple terms, it must have been committed along with the alleged act or immediately thereafter. So what basically it means is it must be part of the same transaction. Then only even hearsay evidence can be made admissible. So they are so connected, so intricately connected that they cannot be severed. That is why they form part of the same transaction and become relevant just like fact and issue. So what do you exactly mean by same transaction? The following factors should be taken into account while ascertaining a particular act as part of the same transaction or not. First, proximity of time. So, what is the duration of time between both the acts? Nearness of place. So, proximity of place again. Then, continuity of action. Can you count it as same action, a continuing action, or completely different action? Community of purpose. Is it continuing along with the purpose that was there from the very beginning? Design of the offense. Again, is it a continuation? Is it the same design? So all these factors should be taken into account before considering same transaction. If it is if it comes under the ambit of same transaction, then only it can come under the ambit of section 6.